About reparations globally, and specifically with regards to the practice of slavery historically across the African diaspora for descendants of African enslaved through colonization. What would such reparations look like in post-colonial nations as well as in the former colonial centers today? Equally important, what is at stake when identity politics are deployed in an attempt to advocate for restorative justice through reparations? How do those disadvantaged by past injustice organize? And what are the politics of naming that are necessary or strategic in working for a more just and equitable world order? And then how do we ensure that in naming movements to fight global inequality, identities of other subaltern subjects are not appropriated or erased? Another question to consider is what remedies exist under international human rights law for making a claim to reparations by people after systemic acts of oppression and injustice, when such acts continue to reverberate into our present, as Kirsten Mullen demonstrated in tracing the origins of many global corporations today to the slave trade. And in that vein, I'm hopeful that this panel will also open up a space to discuss reparations within our current global economic world order, where the spread of global capitalism after the end of the Cold War has entrenched and further widened the global inequity wrought by colonization. As we face the expansion of neoliberalism, which seems unabated, and which has seen corporations become stronger than some or even most nations, is social and economic justice a further receding target, moving further and further away from our grasp, as capitalism dictates the flow of money and people and the opening up of national borders and markets? So with these questions in mind, I hope that we can broaden the question of what kind of country we want to live in, which was posed earlier, to think about what kind of world we want to live in. And so now I'll hand over to our first panelist, Lisa Crooms.
Thank you. Afternoon. Thank you. Thanks for hanging in. This is right. We've got the unenviable task of making you forget what time it is and that it's a Friday. Okay. My comments are entitled Remembering the Dismembered, Renaissance, Reparations, and Pan-Africanism. And the title comes from a book that my home institution, Howard, assigned to all freshmen as what we always have a common text. And there's a freshman seminar built around the common text. And the common text this year was Ngugi wa Thiong'o's Something Torn and New, toward an African Renaissance. So I have to say that I've been thinking about some of this stuff in the context of having to actually teach one of those seminar sessions. And what I'm offering here hopefully will not make anyone want to get up and smack me. But it's offered as just some things to think about. Okay, so I'm trotting this out for the first time. Okay, all right. So Ngugi wa Thiong'o makes the following observation. It could be argued that the political and cultural struggles of Africans since the great dismemberment wrought by European slavery and then colonialism have been driven by the vision of wholeness. These struggles, taken as a whole, have been instrumental as strategies and tactics for remembering the fragmented. Indeed, they have comprised a quest for wholeness. An essential aspect of this quest for wholeness, I believe, is Pan-Africanism, which links Africans and Afro-descendants across the globe based on a shared constructed Africanness that is cultural, ideological, political, spiritual, and other things. How Pan-Africanism, however, plays out largely depends on the point from which it's deployed. For those Africans on the continent, Pan-Africanism is a way of organizing the continent and its activities. It is an African federation to which Africans from throughout the diaspora are welcome. Its success requires individuals to subsume their ethnic identities, which are too often the fault lines along which conflict and violence may in fact form and play out. For Afro-descendants in the diaspora, Pan-Africanism is a way to construct an identity to overcome irrecoverable loss. What has been lost is the ability to know with some certainty the specific place on the continent our ancestors called home. This loss derives from the social depredations of slavery. It is a loss that must be acknowledged and addressed. And this is the first step of reparation, designed to make those injured by slavery, the slave trade, and colonialism whole. But for many, this quest for wholeness is manifested as a quest for home. For most diasporic Africans, however, this ancestral home will never be known beyond the reaction of those exposed to slavery, the slave trade, colonialism, and neocolonialism. Pan-Africanism minimizes this lack of specificity with a generality expressed as an Africanness. And this Africanness, this is the Africanness that is most often expressed by those who, in fact, cannot know. According to Ngugi, this inability to know is an important aspect of the injuries caused by slavery, the slave trade, and colonialism. It is not, however, limited to Afro-descendants in the diaspora. Rather, the thoroughgoing dismembering of African identity and the remembering of a reconstructed Africa using the oppressor's frame of reference is a reality for Africans both on the continent and in the diaspora. For those on the continent, the dismembering was accomplished by extracting Africans from the continent, partitioning the continent among those who benefited most directly from the trade in human flesh, and exploiting the natural resources. For those in the diaspora, dismemberment was accomplished by removing them from their ancestral homes so as to erase Africa from the collective memory beyond what could be passed intergenerationally through human recollection and narrative. Disconnected from home and memory, these Africans in the New World were forced to adapt to harsh and violent realities in which their African identities, refracted through the dominant culture, were used to justify their enslavement. Despite this dismemberment, many Africans in the diaspora managed to influence places they knew only because of the slave trade. According to Ngugi, we've left our mark on cultures and societies rendered more African by our very influence. We've forced the countries to which we were shipped to, in fact, change. Being largely isolated from Africa, the collective imagination of these Afro-descendants was ripe for a reconstructed Africa to which all Africans could lay claim. Early Pan-Africanism marked the initial steps to repair the injuries caused by slavery and the slave trade by seeking to make Afro-descendants whole. As such, reparations would have to be broad enough to remedy the different types of injuries at the end of a causal chain initiated by slavery and the slave trade. The need for reparation reaches economic, liberty-based, and psychic injuries, all of which find their genesis in slavery and the slave trade. In many cases, the lines between these types of injuries were blurred, such as when women's bodies were used for both productive and reproductive labor, as well as when slavery was replaced with institutions such as peonage and apprenticeship. The slave trade represented the aggregation of individual commercial transactions in the market for human beings. These transactions began hundreds of years ago when slavers held forth to Africans whose cooperation they needed on the specious benefits of the slave trade to at least some Africans. And there I'm quoting from Randall Robinson's work, The Debt. In this way, the slave trade affected Africans differently depending on whether they were commodities traded on the international market facilitated by the transatlantic triangular trade or part of the group of Africans who remained on the continent. While all Africans were injured, the nature of the injuries differed significantly based on where the Africans in question were located. That is, the particularity of place made all the difference. Seen in this way, the injuries to the countries and clans from which the enslaved were taken can be conceptualized to include depopulation and the loss of human resources that could have been exploited to benefit Africa and Africans. In this way, you can perhaps view Africa's injuries as being primarily matters of extraction. First, of the human resources of the enslaved, and second, of the natural resources over which the colonizers exercised absolute dominion. Seen in this way, reparations for African countries are defined now to include compensation for the economic losses resulting from the unauthorized extraction and exploitation of the continent's human and natural resources. The usefulness of this type of formulation in the effort to make Africans whole, I contend, may be perhaps called into question because of its equivalence of resource-related injuries, which I believe reinforces the commodification of Africans at the root of slavery and the slave trade. According to Du Bois, the result of the African slave trade and slavery on the European mind and culture was to degrade the position of labor in respect for humanity as such. It should not be surprising, then, that many of those who have embraced this problematic position, that is, the idea that is based on who had a right to exploit the resources, rather than questioning the rightness of exploitation itself, a problematic position, are the descendants, many, are the descendants of the African elite constructed by colonizers steeped in the mutually reinforcing ideas of white superiority and African inferiority. In addition, colonialism fostered a dynamic in which ethnicity determined relationships not only with the colonizers but also between Africans. Indeed, the colonizers exploited these ethnic differences to further the colonial project. The aftermath of colonialism has been marked by intense ethnic conflicts that flare up at the very fault lines emphasized and exaggerated by European colonialists. Quite ironically, these fault lines result from the primary distinction between the effect of slavery, the slave trade, and colonialism on the memory of the continent and that of the diaspora. That is, the specificity of identity on which the vast majority of internal conflicts on the continent are based is the very identity that slavery and the slave trade made virtually impossible for those in the diaspora to know. This suggests, for me, that without significant re-remembering, the Pan-Africanism is more likely to work as a unifying ideology for Africans in the diaspora than for Africans on the continent. Switch gears. So, two, I contend, of the most recent contemporary articulations of the Pan-African agenda for reparations for slavery, the slave trade, and colonialism are found in the OAU's Abuja Proclamation of 1993 and the UN World Conference on Racism, Racial Discrimination, Xenophobia, and Related Intolerances, otherwise known as WCARS, Durban Declaration and Program of Action of 2001. I'm going to begin with Abuja, end with Durban, and hopefully come in under my time. Okay, so Abuja. The first Pan-African Congress on reparations for African enslavement, colonization, and neo-colonization was held in Abuja, Nigeria in 1993. The conference was sponsored by the Organization of African Unity's Group of Eminent Persons and Commission for Reparations, as well as the federal government of the Republic of Nigeria. The conference proclamation set forth the continent's case for reparation for, I quote, the damage done to Africa and its diaspora by enslavement, colonization, and neocolonialism. The proclamation places enslavement and colonization at the beginning of a trajectory that reaches the contemporary conditions in which far too many Africans and Afro-descendants live. Indeed, it contends, and I quote, that the damage sustained by the African peoples is not a thing of the past, but is painfully manifest in the damaged lives of contemporary Africans from Harlem to Harare, in the damaged economies of the black world from Guinea to Guyana, from Somalia to Suriname. It, that being the Abuja Proclamation, seeks to hold to account those states and nations whose economic evolution once depended on slave labor and colonialism, and whose forebears participated either in selling and buying Africans, or in owning them, or in colonizing them. According to the proclamation, the claim for reparations can be made as a matter of both law and morality. Reparations to Africans are justified due to their status as, and I quote, the most humiliated and exploited people of the last 4 centuries of modern history. And that's the end of the quote. Rather than set forth a complete compensation plan, the proclamation calls for specific measures designed to yield well-considered assessments of how best to compensate African peoples. These measures are directed at the OAU, African states, European and American states, and members of civil society. They link debt cancellation for African and Caribbean countries, capital transfers, and special measures for African people in the country, quote, the countries largely characterized as profiteers from the slave trade, and efforts to secure a permanent African seat on the Security Council of the United Nations. Thus, the proclamation makes the case for reparations for all African peoples both on the continent and throughout the diaspora. It does so in terms that see Africa's injuries as largely a matter of exploitation and extraction, robbing the continent of natural, human, and cultural resources. In this calculus, uranium, gold, and diamonds stand side by side with enslaved Africans and artifacts, all of which have been lost to looting, theft, and larceny. It does so with the conviction that the pursuit of reparations by the African peoples in the continent and in the diaspora will itself be a learning experience in self-discovery and in uniting experience politically and psychologically. Now, an essential part, now we go to Durban. Durban's in 2001. We already heard a little bit about what happened at the World Conference Against Racism, particularly with respect to its proximity to 9/11 and how that helped to erase the discussion that many people had already begun to have coming back from Durban about what the Durban Declaration and Program of Action would mean in terms of changing laws, policies, lives, let truth be told, of the folks, in fact, who were going to benefit from what was done in Durban. So the conference produced this combined declaration and program of action, which detailed both the myriad of issues falling within the conference's mandate and the specific recommendations intended to address those issues. Reparations for Africans and Afro-descendants for injuries caused by slavery, the slave trade, colonialism, and neocolonialism are among the issues addressed in the declaration and the program of action. Indeed, the program of action contains 3 specific remedial directives. First, it urges states to ensure that all persons have access to effective and adequate remedies and enjoy the right to seek from competent national tribunals and other national institutions just and adequate reparation and satisfaction for any damage as a result of racism, racial discrimination, xenophobia, and related intolerance. Second, it emphasizes the importance of access to the law and to the courts for complaints of racism and racial discrimination, and draws attention to the need for judicial and other remedies to be made widely known, easily accessible, expeditious, and not unduly complicated. Third, it urges states to adopt the necessary measures as provided by national law to ensure the right of victims to seek just and adequate reparation and satisfaction, to redress acts of measures to prevent the repetition, to redress acts and measures to prevent the repetition of such acts. As formulated, reparations are a remedy to be pursued primarily through the judiciary. 5 minutes, thank you. They are designed to make individual victims whole as well as to prevent the atrocities from being repeated. In light of my time. Okay, so one thing that the Durban Declaration does is it defines or names slavery and the slave trade as a crime against humanity. And part of what I'm not going to, in fact, cover, but will mention, is I've got a question as to whether even the remedies as contemplated by the Rome Statute, by which the International Criminal Court is governed, whether those remedies will in fact do much to make anyone whole. They're largely criminal, and even with life imprisonment, if you could find someone to in fact put in jail, it's unclear as to whether someone being incarcerated will yield the kind of wholeness that one would expect to find with that kind of remedy. Okie. The other thing that's interesting about Durban is that it does make the distinction so that while slavery and the slave trade are defined as crimes against humanity, colonialism and neocolonialism don't rise to that level. Now, they do note, the drafters do, their concerns about the continued and violent occurrence of racism, and that theories of superiority of certain races and cultures over others promoted and practiced during the colonial era continue to be propounded in one form or another even today. And it links colonialism to the fact that developing countries face special difficulties in responding to the challenge of globalization. And according to the delegates to the Durban Conference, while globalization offers great opportunities, at present its benefits are very unevenly shared while its costs are unevenly distributed. So, in the interest of being respectful of my time, I guess what I'd like to end with is, under both Abuja and the Durban documents, there is this notion of the importance of beginning to remember in light of what has been lost. And that's, I believe, a very important commonality. But it does, I think, bring into question the utility of Pan-Africanism as a frame if we're ever to move the claim for reparations from rhetoric to concrete measures designed to make people whole. Because despite the fact that Pan-Africanism attempts to provide an umbrella under which all people of African descent can find themselves, the specifics and the particularities about the injury suffered, it seems, work actually against this notion that there is this universal kind of Africanness on which Pan-Africanism does depend. It's the beginning of a conversation. This by no means is meant as, I'm done with it. But I bring it to the table because it is, I think it's ironic that this very rhetorical tool or this framework seems to work best for those who can never know all about where they came from. And it would seem that that kind of knowledge, in fact, may prove to be an insurmountable obstacle to making Pan-Africanism a reality on the continent itself. Thank you.
Thank you, Barbara. Thank you. First, I would like to thank the organizers of this superb symposium for inviting me, Deborah, Kim, and Laurie, whom I met last year in Paris, and whose reflections on reparations triggered a lot of interest over there. I spent a year at the University of Virginia 20 years ago, so it's great to be back, although I struggled this morning to locate Minor Hall. So you see that my memory at least plays tricks here. The past is not dead or buried. In fact, it's not even past. As Barack Obama reminded us in his speech, A More Perfect Union, the U.S. history of slavery and racial injustice lives on in the present. It is also the case with former slave trading empires in Europe and former slave-holding colonies in the Americas. In France, public debates around slavery as a historical issue and as an object of collective memory have been very visible since the late 1990s. They have revolved around several historical issues, such as the role played by slavery in the French economic takeoff, the everyday life of slaves in French colonies as compared to other colonial imperial forms of slavery. Situations, the number games, like the Atlantic slave trade versus the Oriental slave trade and domestic forms of slavery in Africa. And most importantly here, a series of contemporary questions all linked to the social situations of racial minorities in France. The relationship between past situations of domination, slavery and other forms of colonial oppression or segregation and Jim Crow laws in the United States, and current situations of domination, racial discriminations in French and American society, is at the heart of current debates in post-colonial France. While not being central to the current questioning of the colorblind French Republic and the growing political visibility of French blacks, the issue of reparations for slavery has floated around since 2001, when the French Parliament voted the Taubira law, declaring that slavery is a crime against humanity and urging French and European authorities to promote the study of slavery and commemorate its memory. Most French people have never heard of the possibility of reparations for slavery, let's be frank. And I would even argue that a significant number of French people don't even know that slavery is part of French history. My presentation will describe and analyze the current debate on reparations for slavery in France in a somewhat larger historical framework, and will suggest a pragmatic approach to reparations, which could find a reasonably broad political support. This is something I'm quite attached to. A number of events in recent years have brought the slave past to the forefront of debates about race and politics in the US and Europe. In 2001, as you rightly mentioned, the Conference on Race and Racism in Durban, South Africa, made the question of reparations for slavery central in discussions for the first time in France. The same year, the passage in France of the Taubira law, which I mentioned, declaring slavery and slave trade a crime against humanity, was seen as a landmark. Most scholars have said or written that the Taubira law was a new kind of legal memorialization that had previously been reserved for the Holocaust in Europe. I don't think it's true. As soon as the abolition of 1848 in France, the notion, if not the word, of crime against humanity was created. If you have a close look at the decree of April 17, 1848, which abolished slavery for the second time in France, you know that there were two abolitions. Some people said that we French liked slavery so much that we felt the need to abolish it 2 times. Title 8 of the decree of the 1848 decree forbade any French citizen to own, buy, or sell slaves, or even to indirectly participate in a slave trade-related activity. A very, very unusual punishment was created then. Any French person found guilty would be stripped of his or her French citizenship. This is a unique case in French law. It had never happened. It would never happen again. You can kill the president of the republic. You can be guilty of major war crimes during the Second World War, for example. You can be sentenced to years and years in prison. You will never be stripped of your citizenship. And it's illegal, in fact, in France nowadays and in many, many countries. So why such an unusual punishment in 1848? Well, as the members of the committee who wrote the decree said, slavery is a crime, un crime de lèse-humanité, which could be translated as a crime against humanity. 150 years later, the Taubira law did not invent the legal notion that slavery is a crime against humanity, but it only repeated it, it restated it for a good reason: the burying of the memory of slavery and the development of an ideology of reconciliation, which in fact encouraged the descendants of slaves to forget slavery and imagine their colonial history as a progressive history of emancipation and uplift by the Republic. In the last decades of the 19th century, the yearly celebration of the emancipation was transformed into Fête du Printemps, the commemoration of spring, of Fête du Travail, the commemoration of work. And the mention of slavery was suppressed from official discourses, including by Caribbean politicians themselves. As David Blight and Nina Silber showed in the US case, the situation was similar in this country after the Civil War, when the celebration of their reunion swept on the side more disturbing issues related to slavery and the fate of freed men and freed women. Why didn't the French Republic emphasize the emancipation of 1848, since it was proclaimed, after all, by a republican regime? Well, as Doris Garraway rightly argues, I quote her, both the official recollection and the forgetting of slavery have been instrumental to attempts on the part of the French state to resolve or to displace the question of its possible obligations, legal, ethical, material, and symbolic, towards those it once enslaved, end quote. After the Second World War, the transformation of the old colonies, that is the French Antilles, the Guadeloupe and Martinique islands, into French départements, and the rise of anti-colonialism in the French Empire did not lead to a rediscovery of slavery. However, Aimé Césaire, in his famous Discours sur le colonialisme, forcefully talked about the European crimes and famously argues that Nazism was the importation in Europe of colonial crimes. He wrote on the ambiguity of the abolition. Former slaves remained colonized and their masters were financially compensated for the loss of their slaves in France, right, by contrast with the US. Even if Césaire did not understand the uniqueness of the genocide of European Jews and Gypsies, he underscored the legacy of slavery and the racial bonds it created. To Césaire, by contrast with a more essentialist approach by Léopold Sédar Senghor, blackness, the fact of being black, is the fruit of a historical experience. But much to the regret of Césaire, there was no equivalent in France to the civil rights movement in the United States and its legal and academic legacy. In 1998, the 150th anniversary of the abolition witnessed President Jacques Chirac referring to the abolition as a moment which reinforced the unity of the nation, as he said, not even mentioning the legacy of slavery. The official slogan, all born in 1848, tous nés en 1848, suggested that the nation was born in 1848. However, the same year, a popular mobilization around the memory of slavery with the demonstration of 40,000 plus persons in the streets of Paris clearly showed that the Caribbeans, since they were mostly Caribbeans demonstrating, were asking for the recognition and memorialization of slavery rather than the consensual celebration of its abolition. The Taubira law also decreed that slavery and the slave trade should be accorded the place they deserve in public school curricula, museums, monuments, historical research. The law also included a provision allowing descendants of slaves or associations representing them to prosecute individuals who violate the law by denying that slavery was a crime against humanity. Although the original draft of the bill contained a provision for, I quote, an exploratory committee to examine the question of reparations, end quote, the final version of the law provided instead for a committee which would propose only different ways of memorializing slavery. So the issue of reparation was discussed by the French Parliament in 2001, but swept on the side. So it is very clear that the Taubira law was a limited form of official action, but it had political consequences, and this is something I want to insist on. First, it encouraged the development of associations aiming at uniting French persons of Caribbean origin living in metropolitan France. Among these associations, the Collectif d'Hommes unsuccessfully tried to sue a historian for statements he made in a newspaper on the slave trade. These associations were explicitly organized around the identité antillaise, the French Caribbean identity, not a racial identity underlying the specific historical and social experience of French Caribbeans. They criticized the Taubira law for not including reparations without specifying what kind of reparations would be suited. In fact, the lack of robust intellectual debates in France on reparations around 2001 seems quite obvious when compared to the debates in the US at that time. Also, the refusal to address racial issues, the denial of race as a category of analysis and a basis for action, made for a purely memorial demand regarding slavery, failing to address the links between slavery and more contemporary racial discrimination. A new development, not directly linked to the memorialization of slavery, emerged around 2005. The gradual acknowledgement of the pervasive existence of racial discriminations in modern France, especially after the uprising of 2005 in the French suburbs, which should mainly be analyzed as a rebellion against various forms of racial discrimination, led to more acute critics of the official colorblindness of the Republic. Fighting anti-black racism and discriminations, which are still so pervasive in French society, required the acknowledgement that the French Republican ideology had swept on the side racial issues which were seen as threatening the national cohesion. A new generation of French, African, and Caribbean intellectuals and activists started to think that they had a vested interest based on the social experience of blackness. Sociological investigations as well as the historical inquiries suggest that if there is no black community in France understood as a group with a well-defined identity, there is nevertheless a lowest common denominator, the social experience of being considered as a black person. This social experience is directly linked to the historical construction of the black race, closely associated with powerful systems of domination, slavery, colonization, post-colonial forms of domination and discriminations. These forms of domination have varied in time and also in space. So slavery is central in this history, obviously, but it is not the common denominator of all French blacks. The interviews I conducted several years ago when writing my book suggest that French blacks of African origins do not view slavery with the same eyes as French blacks of Caribbean origin. When asked about reparations, I listened to the tape last week when thinking about this paper, since I did not insist so much on the issue of reparations back then. So when asked about the reparations, French Caribbeans refer to various forms of compensation for the tragedy which their ancestors lived and the consequences on their descendants. They may refer to what the Guadeloupe and Martinique Islands should get from the French states or from French corporations. Mm-hmm. They rarely mention Africa. And when they do so, I must say that I was often surprised by the level of bitterness vis-à-vis Africans, sometimes even accused of having sold their brothers and sisters. So the creolization movement, which has had a strong influence onto French Caribbeans, insists on the unique Creole culture and history and tends to minor the Africanness, as you said, something which puts creolization at odds with Aimé Césaire and the Negritude movement, which started in the 1930s. By contrast, when asked about reparations, French Africans refer to the human losses which Africa suffered and the colonization process in general. So there's groups, the French Africans and the French Caribbeans, disagree on the very meaning of reparation, underlying different historical trajectories and memories. So I found that a purely US-centered analysis of reparations for slavery doesn't often allow to highlight the nuances and tensions over the meaning of reparations among blacks themselves, who are often understood as a fairly coherent, homogeneous group. Although there's a significant and growing population of recent African descent in the United States, as you know, whose perspective on reparations would be worth investigating. That is why, when discussing racial issues and the possibility to unite blacks with a political agenda to fight racial discriminations and anti-black racism, slavery was not the most unifying reference. the contemporary experience of blackness seemed to be more appealing, more useful, less likely to divide Africans and Caribbeans, as well as a more powerful incentive for action. In November of 2005, the creation of the CRAN, the Representative Council of Black Associations, made headlines in France. This federation brings together about 120 associations, some of them being very small, like the Association of Caribbean Male-Men of Seine-et-Marne in the département, or African Women of Mantes-la-Jolie in the suburbs of Paris, some being much larger, such as the Association of Malian in France or the Union of Senegalese of France. Referring explicitly to the American NAACP, the CRAN intended to express the difficulties of French blacks. As a historian who was actively engaged into the birth of this federation, I remember very well that historical questions were raised mostly in light of their consequences for contemporary France. Debates were organized all over the country on the links between slavery and modern forms of racism and discrimination. How is it that the descendants of slaves or colonized people remain at the bottom of French society? In this respect, I have found, in fact, that people were less interested in the history of slavery as such as in the history of the post-1848 colonial and post-colonial societies, the way former slaves and their descendants were subjected to various forms of domination, including symbolic forms such as the erasing of the memory of slavery. I found that descendants of slaves I interviewed are mostly interested in figuring out what went wrong after the abolition, the post-slavery colonial period so vividly described by Aimé Césaire in his plays, for example. They don't believe in the classic slavery to freedom celebratory narrative anymore. So here I insist on the importance of the post-slavery period and the possibility for framing the notion of reparations in terms of racial justice, which takes us beyond slavery understood as a well-defined historical moment ending in 1848 or in 1865. Last October, Prime Minister Jean-Marc Ayrault in France declared that he was in favor of reparations, only to be rebutted by President François Hollande the following day. Ayrault did not specify what he meant when referring to reparations, and he prudently shied away from this issue. If we want to bring the issue back on the table, let's frame it in terms of racial justice. If reparations for slavery remain a divisive issue among French blacks, I have all reasons to believe that French whites would be fiercely opposed to them. I believe that in order to reach some kind of political support in France, we should make a crude distinction between, on one hand, symbolic and educational reparations, and on the other hand, material reparations. When I say material reparations, I understand that when working on symbolic and educational reparations, this has a material dimension. But let's make a distinction between symbols, education on one side, and on the other side, social justice in terms of economics, in terms of who gets what in French society or in American society for that matter. Symbolic and educational reparations, commemorations, museums, history textbooks, academic programs would be linked to past forms of oppression, including slavery and colonization by the French and others. This is a divisive issue in France. A number of prominent historians argued, first, that slavery was not a crime against humanity, and second, that the Taubira law meant to please minority groups, as historian Pierre Nora wrote, with particular demands. Pierre Nora, very prominent historian, spoke of an abuse of particular memories, suggesting that history is rational and aims at some kind of objective knowledge, by contrast with memories, subjective and particular. Conservative historians would argue in France that slavery is a regrettable moment in an otherwise progressive history, which should not be the matter of too much academic and social interest. On the other hand, material reparations could primarily be based on current racial injustice, affirmative action, strong anti-racist and anti-discrimination policies, programs for low-income minorities, including in overseas territories. Anti-black racism and racial discriminations are very serious problems in France, serious enough to justify a vigorous public policy without, I think, the political need to compensate for past injustices. Don't get me wrong here. I wholeheartedly agree with the need to memorialize slavery and teach it and create whatever memorial and education institutions so as to reinforce the place of slavery in the collective memory, let's put it that way. What I want to resist, though, is the tendency to think that reparations for slavery are the best way to enforce racial and social justice in 2013. Thank you.
As the last panel and the last panelist, I thank you again for your forbearance, and I want to thank the organizers for this extraordinarily interesting and wide-ranging conference. I'm going to talk about what I call a new practice of reparations. Legal scholars and philosophers, as well as advocates and opponents, often assume that reparations follows a principle of compensatory or corrective justice, in which wrongdoers are obliged to compensate or make restitution to their victims for wrongful harms and losses. The transaction is meant to restore the victims, as nearly as possible, to the circumstances they were in or would be in had the wrong not occurred. The typical mode of restoration is material, usually monetary. Restitution or compensation by the wrongdoer is supposed to reverse the transaction. The attempt to mold reparations to this logic produces endless and repetitive critiques of reparations for massive violations, and even more so for questions of historical injustice, extending back generations. Here, I discuss a different model for reparations that is emerging internationally, and a different rationale for reparations that it suggests, at least to me. I believe this alternative makes for a better understanding of the complexity and diversity of demands of reparation, including why and when compensation is needed and why it is never enough. It also gives deeper insight into resistance to reparations by states and within societies, which is evident in the case of black redress in the United States, as Professor Dawson so vividly demonstrated, but which is by no means peculiar to that case. The resistance is not really about the money either. A genuinely new practice of reparations has been emerging around the world. It's widely agreed that the payment of reparations by West Germany to individual survivors of the Holocaust after the Second World War introduced this new practice, treating the individual harm and not another nation as the focus of reparations by a state. Extensive programs of reparations for victims and families, and we've heard these mentioned now several times, were instituted in waves in the aftermath, for example, of brutal military governments in Latin American countries, especially Chile and Argentina, that engaged in repression, torture, disappearance, and illegal detention of their citizens. The United States, as we've heard several times, legislated a reparations program in 1988 for Japanese Americans interned during World War II after over 40 years after the events. In light of these and many other developments, and after at least 2 decades of study, the UN General Assembly in 2005 endorsed the basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law, which I'm going to refer to as the basic principles. The basic principles did not invent this new practice of reparations. Instead, it consolidated a wide-ranging and accelerating set of developments in many places. actual programs of reparations, recommendations by truth commissions of appropriate reparations, decisions by international courts, especially the Inter-American Court of Human Rights, reparations by private entities, like churches or corporations, reparations proposals and demands by NGOs and victim advocacy groups, domestic and international lawsuits seeking compensation, and legal and academic scholarship. So there are multiple tributaries that have fed this formulation. It's more, I'm saying, a reflection than it doesn't create, but rather reflects. Now, Section 9 of the Basic Principles stress 5 categories of reparations measures. The first 2 are the familiar ones of restitution and compensation, interpreted broadly. A third is medical, psychological, social, and legal rehabilitation services. The last 2 categories, however, involve very diverse interventions. The category of satisfaction includes 8 distinct measures: to stop ongoing violations, to verify and disclose the truth publicly, to search for and rebury those disappeared or abducted, to officially declare the reputation and rights of victims, to apologize publicly, to sanction responsible parties administratively or judicially, to commemorate and honor victims, and to include an accurate account of violations in educational materials. The final 5th category, guarantees of non-repetition, includes a variety of preventive measures: an independent judiciary, due process guarantees, civilian control of the military, training and education of public officials, monitoring, and institutional and legal reforms. These are, not accidentally, all measures that have been recommended repeatedly in Truth Commission reports, which have found the absence of just these things to be among the causes and circumstances of gross abuses. I want to call attention to 3 features of the multiform practice described. First, the basic principles are addressed to states, and state responsibility for reparations is assumed. Several kinds of measures mentioned can only be provided by state institutions. The principles acknowledge that where other persons or entities are liable, they should provide reparations. But if other liable parties are unable or unwilling, states should establish national reparations programs. So final responsibility rests with the state. Second, the principles expressly and repeatedly recognize that victimization of individual persons may also be directed against groups of persons who are targeted collectively, and that states should develop procedures to allow groups of victims to pursue and receive reparations, including collective reparations. Now, third, the principles do not rank the different categories of reparations measures. Restitution and compensation are paradigmatic legal remedies, but practice has revealed that acknowledgement, responsibility-taking, truth-telling, apology, and memorialization, as well as credible guarantees of non-repetition, often turn out to be foremost in importance to individuals and groups who have suffered human rights abuses. The common distinction, and maybe on the other side of this with you, the common distinction, and it is common, between material and symbolic reparations, while useful for some purposes, can be very misleading in some ways as well. A symbol or a symbolic gesture is what stands in for or represents something else that is absent or only indicated. To call some reparations, such as apologies, truth-telling, or commemoration, symbolic, which in fact is often the way this is used, it can be to imply that they are not the real thing. Yet one thing learned in contemporary reparations attempts is how essential it is to victims of wrong that money be accompanied by or be part of truth-telling, responsibility-taking, and gestures of respect toward victims. Even where it is necessary, money is not sufficient. money may be refused or understood as insulting in the absence of honest accountability, respectful recognition, and clear admission of wrongs, as was illustrated in the case of the so-called, unhappily called comfort women who were sexually enslaved in the Second World War, and many of whom continued in their old age and often ill state to refuse what was offered because it came from the wrong place and with the wrong kind of apology, the common root being that it was not an admission by the government of Japan, that it had to take responsibility for their sexual enslavement. So the material symbolic distinction, but there's a second problem with the material symbolic distinction. It also fails to capture at one and the same time the concrete, material, but also expressive role played by preventive reforms, the whole guarantees of non-repetition. To undertake major change in societal institutions tells victims and society as a whole that what happened to the victims is intolerable and it cannot be allowed to happen again. In sum, the new practice of reparations assumes state responsibility as primary, although it sets a model for reparations by other entities. It recognizes that in massive wrongs, individuals may have suffered and so must be redressed in some cases as members of groups, and promotes a set of very diverse measures which respect, assist, and support victims and make a societal commitment that their suffering not be repeated. Now, a significant part of what has been written on reparations in recent decades is concerned with showing why attempts at reparations, understood as an exercise of corrective justice, just can't work or don't make sense, or even simply create new injustices. You're going to make people pay who aren't responsible and so on. But is the assumption that reparations can be or must be understood as an application of corrective justice right? Corrective justice itself, and we've already seen this addressed by Professor Davis, corrective justice itself, the idea that one party or group can hold another to account for wrongful harm suffered, can pose terms of restitution or compensation, and can seek a resolution in that way, presupposes that parties stand in relations of effective accountability and reciprocity, that they can activate these relations when they need correction or redress. Yet it is the absence of precisely these relations that lies at the root of many of the profound harms and gross abuses where reparations are sought. These relationships of accountability and reciprocity may not have obtained at the root historically, as in the case of chattel slavery and its aftermaths of segregation, domination, and racial violence. They might have been inconsistent and fragile, as in the case of treaties and alliances made and then quickly and willfully discarded for conquest, genocide, and dispossession, in the case of Native people. They might have been shallowly or selectively functional until cultural differences, historical resentments, current power struggles, or resource competition gave political opportunists an opening with violent consequences, as in 1930s Germany or the 1990s in Yugoslavia or Rwanda. So the cases vary endlessly, and the details are crucial for reparations in any particular case. But a common factor is that reparations typically seek repair in a context where accountability and reciprocity are themselves deeply at issue, which I think Professor Dawson's plenary brought out very starkly. Accountability is the relationship in which we see each other as answerable to each other under some common standards. Whether I can reprimand you for your table manners or insist on an apology for your lack of consideration or take you to court for a breach of contract. Accountability relations can take formal, legal, or institutional forms, but upholding standards of any kind, from etiquette to human rights, requires accountability between us. If you have the power to be unmoved by my demands, to be indifferent to the harms you cause me, or even to retaliate against me for presuming that I can hold you to account, we do not stand in this most basic moral and social relation. And if I have the privilege of assuming that what goes for me need not go for you, that I deserve protection but you deserve none, that I can demand your attention but you may not dare to insist on mine, then we are not in a relationship of reciprocity at some level, perhaps even at the level of human decency. It is the absence of accountability and reciprocity that lies at the root of the kinds of gross violations and profound harms to which programs of reparations respond. I suggest that signifying the possibility of a relationship of accountability and reciprocity, where there has been none, or where it has been dangerously unreliable, is the fundamental task of reparations, to which all its varied measures are a means. It's something we can begin to see in what I've called the new practice of reparations. It's also visible in a spreading rejection of the corrective justice or tort model of reparations. Obviously, not everyone is rejecting this. A few examples. Yamamoto, Kim, and Holden see international practice as a model of, quote, remaking societal understandings of who is worthy of redress, end quote. Lawyer David Gray writes that reparations must aim at new social and material conditions in order to, quote, achieve a sustainable new equilibrium among members of groups, end quote, and to identify victims, quote, as individuals capable of being wronged. Pablo de Grief, who is the new UN Special Rapporteur for Transitional Justice, says reparations must aim at recognition of victims as people with rights and reestablishing trust between citizens and in institutions based on confidence that shared values are real and regarded as binding on all. These are all questions of reconstituting accountability and reciprocity. They're all questions about generating or returning to a different form of relationship. Now, my own view of reparations emphasizes as well the central but neglected role of hope. Since reparations can only ever be particular measures or programs at particular times, they cannot bear the whole weight of actually remaking understandings, actually bringing about a new equilibrium, or establishing trust. They can only inspire a willingness for victims of injustice to believe and to try for better relationships if others will show an understanding of past wrongs and failed relationships and accept the need for gestures of amends for the past and guarantees for the future. If others become accountable, then hope is reasonable, and it becomes possible to seek reciprocity, equilibrium, and trust. Reorienting reparations to the issue of reconstructing relationships socially, legally, and economically might in turn let us look more clearly at the real practical problems of reparations rather than at an increasingly repetitive set of academic debates. The real problem, or one real problem, is what I will call the reparations deficit. So this is the last part. Despite ever more refined and complex understandings of reparations that are reflected in, for example, the basic principles, not much that is truly attuned to the needs, perceptions, and desires of victims of mass violence and injustice is being done in the world in the way of reparations. The main reparations deficit is that reparations are the least favored among measures that are seen as what's now called transitional justice. A recently published database, this is the Olson, Payne, and Ryder database, on transitional justice measures around the globe, finds that at least financial reparations, which was what they tracked, financial reparations trail far behind either criminal trials or truth commissions in transitional contexts, although all of these measures, justice-related measures, trail miserably behind some forms of amnesty. and official policy to close the books and move on. So when you step back and look at the big picture, I actually give my students this table, and I just say at a glance, quickly, what do states not particularly want to do? And you can literally see at a glance that it's reparations. Ruben Carranza, director of the Reparative Justice Program of the International Center for Transitional Justice, comments, quote, reparations are arguably the most victim-centered of the various approaches to fighting impunity. But in recent years, most of the international resources meant for transitional justice and peace building have gone to operating war crimes tribunals, occasionally to truth commissions, certainly to reintegrating ex-combatants, often the perpetrators, but seldom, if ever, to directly benefit victims of human rights violations. End quote. Reparations are a low priority, domestically and internationally. The other deficit is one within current practices of reparations. Victims of violence and severe injustice who receive reparations, in fact, receive little, with very few exceptions, have what they receive determined by others, and receive what those others decide it is affordable or efficient to provide. If we ask why reparations happen so infrequently, amount to so little, and often fail to engage with actual needs and perspectives of the individuals and groups who seek justice, it's important to understand what's at stake. I've suggested that restitution and compensation are often crucial instruments of reparations. But they are not, as the corrective justice model would have it, what is centrally at stake. I proposed, in the spirit of newer moral political accounts of reparations, of which I gave just a few examples, that it is a renegotiation of relationship that reparations always symbolize and promise. They are an attempt in the present to acknowledge and repudiate what happened before and to begin a transformation by attempting a first step, here and now, toward defining and creating relations of accountability and reciprocity. If a nation, institution, or group avoids making or refuses to make reparations, they hold themselves, even now as before, beyond accountability to the people they have injured or whose mistreatment it falls to their society to repair. They see themselves, even now as before, as having the power to refuse demands of justice from those who deserve reparations. Since in many conflicts the brunt of harms is borne by those who are members of groups already less or least powerful and privileged, those who deserve reparations are generally not in a strong position to compel fulfillment of their claims. If a nation, institution, or group attempts reparations without seeking to hear and understand the needs and perspectives of those who would receive reparations, then there is a failure of reciprocity. Those who would decide reparations based solely on their own perspective and assessment of what is due and what they are willing to offer reserve the right to decide for others rather than with them. They show, now as before, no willingness to meet the others on the ground of shared standards and mutual responsibility. Accountability and reciprocity are the basic terms of moral relationship. They are what reparations, whatever form they take, must try to signify. It cannot be true that these must already be in place for reparations to move forward. That threatens to make reparations possible only when they are least relevant. Instead, the struggle for reparations itself, so long as it can begin to engage, is a focus point and a medium for beginning to move forward, although not smoothly, swiftly, or continuously, toward a picture of what relationships of accountability and reciprocity might look like where they have not existed before. Unlike an exercise of corrective justice that settles up and closes the case, reparations open that passageway. They are the beginning, not the end, of a different history. Thanks.
Thank you to our panel. And we'll take questions now.
Thank you all for this wonderful panel. Usually the final panel always kind of, it's like, but this was just a wonderful, wonderful, inspiring way to end. So thank you. So Margaret and I were talking a little bit earlier about how this wonderful point of overlap between the end of my paper and the beginning of hers. And so I really want to thank you for that. And I think that your the final piece that you were articulating, I'm finding very useful in trying to think through another related model of reparations, which is Roy Brooks' model of atonement, which I think many people find very attractive and has, I think, a lot to say for it. And Brooks insists that that one of the things that reparations demands is forgiveness from the victim, which has never really sat very well with me. And so, so what I really like about the way that you're modeling it is that instead of forgiveness being demanded, that if it is the promise of accountability and the promise of reciprocity moving forward, and instead what is demanded of the victim or asked of the victim through reparations is hope and trust moving forward. And I just want to really commend you, because I'm finding that to be just a far more satisfying framework than the demand for automatic forgiveness, which would sort of be a very presentist model. I have to forgive you right now because you're promising to do something for me in the future, versus really this restoration of relationships. And so I really just want to say I thank you very much for that, and I'm just finding it much more satisfactory than the pure.
So, in order for this model to work, the principals have to agree that it's desirable, right? What do you do? Do you abandon expectations of reparations when a relationship of reciprocity and accountability cannot be commanded?
Well, that's the dilemma. The dilemma being that there's a certain, at least, a certain, even if unstable condition has to exist, I think, for any set of reparations demands or an offer of reparations to engage. It's not it's a huge thing for that moment to occur, but it seems to me to look at reparations as a transaction such that when it's done, you're done. That really what has been wrong is literally set right, is rectified. This seems to me to be impossible. So on the one hand, you have an interesting, a vital set of questions. What are the conditions under which a potential reparations transaction begins to engage? What are the social conditions? I said to Professor Dawson, I think this morning, that I've been thinking we need a lot more of sort of political psychology and sociology to understand what are the thresholds where that can begin to engage. But the other thing I think is that even if something that is even roughly mutually satisfactory transpires, reparations is always going to be a finite set of specific interactions. The way I view this is they are promissory, but that promise can be broken. It can fail. So this is the bit about hope and trust. It remains to be seen whether what has been tokened in a reparations gesture, even a robust one, is really going to be reliable into the future. So you've got you've got instability in the situation of how do we get to the moment where this can engage, and then there is even greater question of, is this for real? Will there be changes? Will there be a transformation in relationships?
This is very helpful. So even the idea of the relationship based on mutual recognition, reciprocity, accountability, even that can remain in flux, that one can initiate a process. But the objective of this model would never be, am I right in inferring, would never be to repair that relationship once and for all. that things would be negotiated and renegotiated over time and depending on context.
Yeah, I think actually there's a way in which this makes reparations seem sort of more open-ended and hopeful. It actually, in another way, is kind of a pessimistic picture, because I think when you think about what the stakes are for reparations, there is a reason, I'm saying, in a way, there's a reason why those who have had the power to do what they did that now merits reparations are very reluctant to open that door if they're going to genuinely engage, because they in that, when they do that, I think that sense of the threat that they're going to actually have to begin to engage in something like reciprocity and accountability, well, that's epical.
Yeah, just really.
Where are the parties in power?
Yeah, one last, because somebody else has to get in. But it's so dependent on these murky affective phenomena.
Well, I'm not so sure it is. At the individual level, certainly, attitudinal changes in belief are very important. But, for example, I stress the way guarantees of non-repetition actually figure in these international norms. There are many very definite institutional, structural changes. There are authoritative shifts in the historical record. It's not just about what people feel. It's about what a society commits itself to that then can either foster or thwart on an interpersonal and social level those attitudes.
I just want to add one other thing that we haven't talked about today that I think is really important to your point, Deborah, especially the affective piece, is the difference between voluntary and involuntary reparation. Right. So one of the arguably most successful reparations models, Germany's payments to Israel, were of course notoriously involuntary. And yet, I think partially to Margaret's point, they're a crucial part of remaking German affect, even though they are imposed on them. So I've always speculated with my students who really resist this notion of the U.S. as unfinished transitional justice, what would it have meant had Europe been more involved in the Civil War and had slavery entered with sort of foreign position, and that reparations had been imposed on the United States by war and, say, by Europe, what would that have looked like? And so I think it's really interesting to distinguish between voluntary and involuntary. Very helpful.
Yeah, I have a question for Pap. Can you tell us a bit more about the debate about the law, and especially the writing of history? It seems, from what I've understood at the time, that people who opposed, who mounted this opposition, like Pierre Dara you mentioned, recognized, of course, the Parliament's right and even duty to legislate on all of these matters, whether it was abolishing slavery in 1848 or whether it was voting reparations, if that's what the governments decides to do and has the vote to do so, but did not recognize the right of the same Parliament to legislate history or the writing of. That was a whole different matter. And can you say more about this?
Yeah, it was indeed a fairly lively debate, which was not so much triggered by the vote of the Taubira law in 2001 as by the failed prosecution which a historian went through in 2005. So it really took off in 2005 when a number of historians feared that the Taubira law would allow associations to prosecute historians for whatever they write on the history of slavery. Right. So you would you would write something and then you would be sued and you could be condemned, right? That was what Pierre Nora and others feared. But in fact, this never happened since this association retreated, and no historian since 2005 has been threatened by any associations on legal grounds. And the same is true with the so-called Gesell law of 1990, which is also often mentioned. This law, which might seem so strange to you because we don't have the First Amendment in France. So this law prohibits anyone to question the reality of the Holocaust. Right? If you do so, you prosecute it and you can be condemned. Right? So it's a way to fight against so-called historians who in the 1970s and 1980s wrote books and papers denying the reality of the extermination of European Jews. So the law is very much against that. So, but when you look at the situation since 1990, no historian has been prosecuted. No serious historian has been threatened by the Gesell law. So that was the fear of these historians. But beyond that, what these historians really don't like or don't buy is the possibility, in fact, to integrate into the national narratives parts of our national history which are darker than what they want. And clearly what Pierre Nora says beyond those legal issues, he considers that the history of slavery is a particular history linked to specific groups of people, which should not be seen as central to the history of France, to the history of the economic takeoff of France in the 18th century, and so on and so forth. It's a way to downplay and to marginalize the history of slavery. I guess you would disagree with that, with what I say, but this is... And it's also a way to transform the history of slavery into a matter of memory. Okay, it's for those people. It's for them. It's little something for them. And many historians protested against Pierre Nora's conservative understanding of that. And since 2005, I would say that the debate has calmed down. I haven't heard Pierre Nora saying anything on that. My understanding is also that there is a new generation of historians in France who do consider that studying the history of slavery or studying the history of colonization is not only a good thing from an academic standpoint, is a good scientific and legitimate scientific purpose, but it is also a civic duty. It is also a civic duty in a country where the simple acknowledgement of the social and political consequences of slavery is still seen as radical, as something which is not legitimate. So things, the situation is changing in France, and for the better, I would argue. I'm a historian, but I'm also an activist involved into issues related to anti-discriminatory mobilization and anti-black mobilizations. And I don't want to, I liked your paper, and I don't want to give you the feeling that I'm against reparations for slavery. I'm just thinking in strategic terms, politically speaking, in France as it is in 2013, or in the United States as they are nowadays. Okay, is there a political basis for reparations for slavery nowadays in France? My answer would be no. Okay, I regret that for sure, for all kind of reasons. So can we bypass that and concentrate on current issues, which I'm very much concerned about, the current issues of the rise of racism in France, the rise of extreme right violences in France and in Europe, for that matter. This is the situation we have to deal in France nowadays, right? And from a political and strategic standpoint, I feel that if we focus too much on the issue of reparations, then we tend to shrink our political and social basis. That's my concern, right? If we want to include as many people as possible, including African blacks, as I said, including large parts of the white population, we need to find a kind of political argument that would appeal to a majority or a large portion of the French population. And the kind of political argument that works best, I think, is the kind of argument that focuses on the current situation. Let's say injustices, racial injustices in France nowadays. And I think this works better than incorporating historical arguments which as such are intellectually interesting, and I'm all in favor of a conversation about that. But I'm just saying that politically speaking, it might not be the best move, at least in the French case.
So if they are you? Okay.